Good Saturday morning, Sunday afternoon, no matter where you are in the city. Thank you for joining us today on From the Halls of Justice. In the studio today, we are really honored. My partner and I have secured an interview with Mr. Daniel Hales, and Mr. Hales is an attorney. He does estate planning, but this man is the president of his firm, Citadel, and he has a JD, he has an MBA, he is a certified estate planner, and he has a certified PhD. I couldn't say all those other words, but I was really impressed. And my partner, Murvet Arnstein, who is also a world traveler, and she said, she's the one who came up with this show, and she said, Wanda, let's do a show on estate planning. And so our forte, what we try to do is always bring you the creme de la creme, the best of the best. And that's how we ended up with Mr. Dan Hales. So I'm going to turn this over to Murvet, and you go ahead and...
Well, welcome to our show.
It's great to be here.
Well, since this segment will be about estate planning, let's just start with what is an estate and who needs an estate plan?
Well, sometimes when people hear the word estate, they think that implies tremendous wealth, like a Rockefeller or a Carnegie, but it's really not true. In the state of California, if someone has assets greater than $100,000, that's what California considers an estate. And it's $100,000 of gross assets. So that doesn't even include any debt. So for example, if a person had a home worth $500,000 and they had a $450,000 mortgage, meaning they only have $50,000 of equity, you would think they would have an estate of just $50,000, but actually under California law, that's a $500,000 estate, and that's really what it gets down to. Under California law, anyone that owns a home or has more than $100,000 in gross assets, they have an estate.
That's pretty good. I didn't know that.
I neither did I. So, and also like to know what's the difference between a will and a trust. How do you plan your trust and your will, whichever is important? I really don't know the difference.
Well, that's a good question, and in fact, my clients ask me that question almost every day. What's the difference between a will and a trust? A will is a more old-fashioned document that is either completely handwritten and signed by the testator.
That's a holographic will, huh?
That's a holographic will.
Yeah.
Completely handwritten. Mm-hmm. No part of it can be typed, and there are no witnesses that are required. Mm-hmm. You can do your own holographic will on a napkin in a restaurant, mm-hmm. or on a piece of blank paper, and sign it by yourself. Or there's a statutory will, which is typed and signed by the testator, and in California there are two witnesses. Mm-hmm. So a will is a document that once it's executed and witnessed, if it's a standard will, it will just stay in a person's file or in their office until they pass away, and then the will is admitted to probate, the probate court. And every county in California, in fact every county in the United States has a probate court, and all wills go through probate. So the will goes into the court, and the court is there to make sure the signature is valid, mm-hmm. and they appraise all of the assets, and they hire a probate referee to supervise the process, and an attorney is hired to represent the estate, and it's a fairly lengthy public process to get through the probate court. And on average it takes about 9 months to 2 years. 20 months would be about average for probate.
Oh my God.
I think the longest probate in California history is about 75 years.
No.
So somewhere between 20 months and 75 years. And that's what it takes for a will to wind its way through the probate court.
Wow. Oh, and I forgot to mention something. The reason why Mr. Hales, why he knows all this stuff, is I forgot to mention he has 20 years of experience. Is that correct?
Just over 20 years, right?
Over 20 years of experience, and you look like you're 30. So it's remarkable. But okay, so I can't believe that probate takes that long, though. And all of this.
And people just wait.
People just wait, and nobody likes to wait for their money.
Yeah.
But we're waiting for creditors to file claims. We're publishing the proceedings in the newspaper to notify the world at large that somebody has passed, and if anybody thinks they're entitled to part of the estate, they can come right down to the public probate court and make a claim.
How do you avoid probate?
Yeah.
Well, that's the second answer to Murvet's question.
Oh, okay.
A trust is a great way to avoid probate, because a trust is a form of ongoing title. It's a living legal entity, and it doesn't go through probate provided that it owns one's assets. So the idea is to take your home or your stock that you have in your portfolio, or if you have a business, and you transfer title to all of those things into your trust where you hold it. And it's a living legal entity, kind of like a corporation, but it doesn't die when the person dies. The trust is still there, and it carries those assets through to the named beneficiaries, and they won't get it all at once necessarily. You can set forth ages, so young children have to graduate from college before they get their money. Maybe they can get money for their education, they can get money for medical care and support, but they're not going to get that last big check in their hot little hands until they're whatever age you say, maybe 30 or 40. Because remember, after you're gone, your trust is still there, and it can do what you would do if you were there.
So you plan all these.
Yeah, you plan your children's
future so they don't get the whole money all at once and go spend it all.
Right.
Now, you mentioned an interesting tidbit about Michael Jackson having a will and a trust, but it wasn't funded?
Well, that's right. I mean, Michael Jackson did have a trust, we know that, and yet we also know that his estate is in probate court. And remember, the big difference between a will and a trust is a will has to go through the expensive probate process, and a trust doesn't. So people create trust to save time and save money. So if Michael Jackson had a trust, why is he in probate court? And the answer is that many of his assets, royalties, different entities, were not properly transferred to the trust. So the trust didn't have control or ownership to all the title of the assets, so they still have to go through a probate anyway.
So how much would a probate court cost? I mean, say a person has a limited amount, it's a will, and goes into probate. How much, what's the expenses involved in that?
Yeah, the probate fees in California are dictated by the California Probate Code. So they're set forth under statute by the law. So the lawyer does not choose his fee. The California legislature has already said that the attorney's fee is about 2 to 4% of the gross estate, and the executor's fee is another 2 to 4%. And then you have the court costs, the filing fees, the publication fees, bonds, commissions, appraisals, all of that gets added up together, and it's about 6 to 8% of the gross estate.
Okay.
So if you take the value of all of your assets, don't subtract any mortgages, and just multiply it by, say, 6 or 8%, that's what probate costs.
Oh.
And it can be very, very expensive.
The executor gets a fee?
Executor gets the same fee as the lawyer, which is 2 to 4% of the gross value of the estate.
Then what's the difference between an executor and a trustee?
Well, the trust has a manager, and that manager is called a trustee. A will has a kind of a manager too, and we call the person who manages the will, that person is an executor.
Oh, okay.
And they're typically the same person. So a trust has a trustee, and a will has an executor.
Oh, okay.
Okay, so this is what happens when you try to explain things to people that don't have an estate, I guess. But
You're so modest.
Thank you. No. All right, so the will has an executor, and they get a fee. and the trust has the trustee, but they get a fee too? They don't get a fee?
Well, if we organize an estate plan right, we won't really use the will. We'll create a trust, and we'll transfer the title to the house into the trust, and we'll change the bank accounts into the trust.
Okay.
And the client will have complete control of that. And the will just sit there. Remember, a will only becomes effective after death.
Right.
And if everything's in the trust, we won't even need the will. But the will is there, again, as a safety net. So just in case the client forgot to put a bank account into their trust, or they left a property or a business outside the trust, the will, it's called a pour-over will, it'll catch that asset and it'll pour it into the trust.
Okay.
So basically, we don't really want to use the will because the will is expensive. It has to go through court. It could be 8%, and we really don't. We want to transfer everything to the trust, and that'll avoid us even having to incur the executor's fee or the attorney's fee.
I have a question, but go ahead. Do you want to?
Who to choose as a trustee? Who would be a good candidate?
Well, that's a fun question that every family gets to wrestle with. Because you handle your own finances, right?
Right.
And a husband and a wife generally are in control of their assets, and if a child needs money, they're the ones that write the check, and they say, okay, you can have this much or you can't have this much. So when you pass away, you've got to choose someone to be in control of all of that. And that person is going to be managing your children's futures, investing the money. You should, above all, pick someone that you trust. Pick someone that's honest. Pick someone that has some familiarity with your assets and with your family. It can be one of the family members. You can choose a child to be the trustee. In fact, I usually recommend that people choose someone in their family that can be the trustee instead of hiring a professional. With a living trust, you really don't need to hire a bank or even a lawyer to be the trustee. You'll be the first trustee, and you and your husband will be the first trustees, and the successor trustees could be your own children. And you can pick one trustee, or you can pick two, and these people can act as co-trustees. You don't want too many, because when you have too many cooks, it can spoil the broth, right?
Yeah.
But you can have 1 to 3 trustees, and you should always have some backup. So if the first one can't do it, then you can move to the second or third.
I see.
So someone you trust, someone that's honest, someone that has some experience in finance. At least they know how to balance a checkbook, and someone that's smart enough to know that if they don't understand something, they can always consult with an attorney or a professional advisor or a CPA that can answer their questions.
Okay,
Is it true in the state of California that if you're adopted that you cannot be disinherited?
No, that's not true. Because a person, actually, when you're a parent of a natural-born child or even a legally adopted child, you still have the right to decide if you want to leave them any of your money or not.
I thought that... I heard that if you were adopted that they could not disinherit you.
No, you don't have to leave money to an adopted child, but in your will or your trust, you must specify that adopted child's name. You have to mention them as a full child, and you have to declare in the will or the trust what they receive, whether it's half the estate, $1, or nothing.
Wow.
Now, there are jurisdictions and there are countries where adopted children do have to inherit. France, for example, they have laws of forced heirship. You can't choose entirely who you leave your money to. It has to go to children, and including adopted children. But I've had clients over the years that adopted a child. They were very close.